Hi, I'm Jonathan Stewart. Welcome to Legal Responsibilities for Nurses. In this brief lecture, I'm going to introduce the course, discuss how to think about legal rules in terms of rules, exceptions, and exceptions to the exceptions. I'll talk about the invisible web of rights and duties that link nurses to patients and their employers, healthcare organizations, and to the state, and to others within the complex healthcare ecosystem. And finally, we'll review the basic structure of governments and sources of law. Let's start with why this course is part of your curriculum. The big idea is this. Healthcare is a very heavily regulated industry, but among nurses, there's a lot of ignorance of the law and a lot of incorrect information floating around, and this causes real problems. For example, many nurses incorrectly believe that a pregnant teen, or one who has had a baby, is an emancipated minor who can consent to her own treatment. This is just not true, and it can cause serious problems. Of course, the problem of ignorance and misinformation about the law is not limited to nurses. For example, some physicians believe that if their patient is incapacitated and unable to give consent to a procedure, they can just have a second physician sign the verification of consent form on the patient's behalf. Again, this is wrong, and although it's primarily a physician-driven error, nurses need to know the rules so they can intervene to prevent a violation of patient rights and exposing their employer to liability. From my perspective, as a lawyer who has represented nurses facing discipline by state boards of nursing, and as a risk manager who has investigated events and managed malpractice claims, I have seen how ignorance and misunderstanding of the law can cause serious problems for nurses. And the most common situation is one in which the nurse causes his or her employer to violate the law, resulting in large fines. And one classic example of that is the home health nurse who leaves his or her laptop in the car. It's stolen. It contains patient's protected health information. It has to be reported to the state, to the federal government, and to every patient whose PHI might have been compromised. And I just read that the average HIPAA fine for stolen laptops is $880,000. So if your error causes your employer to have to pay $880,000 in fines, probably not going to be good for your career, just as a general rule. And so these are the sorts of things that I'm here to help you avoid. So I'm going to point out hazards in the environment, hazards in the legal and regulatory landscape, so you can be mindful of them, so you can be circumspect, and so you can avoid them and sail through into a successful nursing career. Now, I should add that although it's much less common, but it's more severe when it does happen, nurses unknowingly engage in unprofessional conduct of some kind and are disciplined by the Board of Nursing, or through ignorance they commit malpractice, which is resolved through the tort system. And these are relatively rare, but when they do happen to a particular nurse, they're pretty catastrophic. And also, just based on my observations, as I've gone through my career, I'm sad to say it, but I also see nurses taken advantage of by their employers on a fairly regular basis because, in part, nurses don't know their rights as employees. Obviously, you will want to avoid all of these problems as you're launching your nursing career, and this class will help you identify the most important rules to know and the equally important exceptions to those rules. So let's talk about that for a moment. As you begin to learn legal rules, it can definitely be confusing and intimidating because there are a lot of rules and not all of them are intuitive, so they just have to be memorized. And there are also a lot of exceptions to the rules. And so let's talk about that. In this course, you'll be learning a number of basic and intermediate level complexity rules. And as I mentioned, many of those rules have important exceptions that you also need to know. For example, consent to life-saving treatment is assumed in emergencies, right? except when the patient has already communicated a decision that they would not want future treatment of a particular kind. Like, for example, if somebody has already made a healthcare decision, if my heart stops, I do not want CPR, then you cannot presume that they would consent to chest compressions if their heart does in fact stop. So there's the general rule and there's the exception. And sometimes you'll need to know the exceptions to the exceptions, but for the purposes of this class, not normally. But I will show you an example. So we're not studying the HIPAA privacy rule right now. I'm just using this as an illustration. So put simply, the general rule is that no personally identifiable protected health information, which is something that has a specific legal definition, none of that can be accessed, used, or disclosed without a patient's permission. But the exceptions are as big as the rule. You don't need the patient's permission to access, use, or disclose their protected health information if it's for the purposes of treatment, or payment, or operations, or if it's required by law. But wait, there are some exceptions to the exceptions. For example, if you go to a clinic for treatment, your clinic can send your detailed health information to the insurance company for purposes of payment without your permission, except certain sensitive records carved out by law, like psychotherapy notes or your HIV status or your substance abuse treatment records, cannot be sent without your permission. And of course, you won't be working in the billing department, so you don't need to know that level of detail to carry out your legal duties at work, and certainly I'm not going to test you on that nuance during this course. But the point is, I'm illustrating there's the general rule, exceptions, and sometimes exceptions to the exceptions. And you know, at a higher level, I'm starting to communicate that there are rights and duties that are part of the legal landscape. And so in this case, the clinic has a duty to protect your privacy, and you have a right to have your privacy or the confidentiality of your health information protected. So let's talk about that. Let's talk about the reciprocating, which means going back and forth, reciprocating promises that we call rights and duties. There is an invisible network of these reciprocating legal rights and duties that links the various parts of the healthcare ecosystem. The purpose of this course, in part, is to make some of these relationships visible and to advise you on how to conduct yourself professionally so that during the course of your career you fulfill all of your duties, expect that your rights are respected by your employer and by others, and that you be mindful of the risks incurred when various legal duties are breached. So in this presentation, I'll be introducing you to the relationships of which you need to be aware as a professional nurse, and this will provide some structure, hopefully, for how we will approach the topics during the semester. So before we actually get to the little diagram, a couple of additional notes. For every right, there is a corresponding duty. So if somebody has a right, somebody else is the holder of the duty toward them. Also, most of the rights and duties that we'll discuss are implied. The parties don't actually talk about it explicitly because the expectations are already set by law or regulations. They don't actually sit down and write out a contract and shake hands. And I guess the other thing I would mention is that these rights and duties we're going to look at are not a complete exhaustive list. They're just what I think you need to know at this level of your education. So we'll start with the fundamental dyad, the physician-patient relationship. If this were a molecule, it would be H2O. It's as basic as water in organic chemistry. But what we're interested in, actually, is the bonds between these two parties. So among other things, the patient promises to pay the physician, and the physician promises to provide medical services non-negligently, to respect the patient's right to make decisions for him or herself, not to do anything to them without the patient's permission, etc. But what does that all mean exactly? Well, we'll discuss what non-negligent professional services means in Week 8, and what respect for the patient's autonomy looks like when it comes to consent and refusal in Weeks 4 and 5. And of course, the promise to pay really means I promise you'll get paid, either by me or by somebody else. We'll talk about that in a few minutes. Now, let's say the physician determines that their patient needs something that he or she cannot provide him or herself. So, the physician writes a prescription for, let's say, hospitalization and IV antibiotics. The hospital has a separate bundle of reciprocating legal duties with the patient. And the patient also promises to pay the hospital for hospital services. These include room and board, lab, medical imaging tests, pharmacy services, the use of medical devices like IV pumps, consumable items like IV tubing and Foley catheters, and of course, all of the technologists and therapists and ancillary and nursing services. For the purposes of payment, nursing services are bundled into facility charges, but nursing does have some independent legal duties that are directed towards patients, and that's what we'll be talking about in weeks 4 through 10. Of course, there are also some promises between the healthcare organization and the nurse it employs. The nurse makes lots of promises to come to work when scheduled, on time and sober, to follow all of the employer's policies and procedures and to obey their supervisors, to keep their nursing license and any certifications current, to perform their duties non-negligently and not to expose their employer to liability. And in return, the employer promises to compensate the nurse with money and benefits and gratitude and glamour, maybe exaggerating about the last two. Employers make lots of other very important promises as well, although technically they're making them to the federal government and actually mostly to the state of California in exchange for permission to operate a business in the state. But the nurse who's an employee gets the benefit of many of these promises. These include the promise to provide a safe workplace and to carry workers' compensation insurance. The employer promises to provide the meal and rest periods required by law. Employers promise to pay wages in accordance with the wage and hour laws of the state, to protect employees from unlawful harassment and discrimination and retaliation. You get the idea. We'll be talking about all of these rights and duties that make up this bundle during weeks 14 and 15. One other bundle of promises we're going to talk about in this course is the relationship between the state and licensed healthcare professionals, and nurses in particular. Basically, in exchange for permission from the state to hold yourself out to the public as a registered nurse and be eligible for jobs that nobody else can get, you promise to do a lot of things. You promise to pay a licensing fee and keep your mailing address updated, and to be professional and competent, and to have good moral character, and never to misuse your power over vulnerable people. And we'll talk about all of these and more during weeks 2 and 3. Before we leave this section, I recognize that some of you might have gotten stuck on the part where the patient promises to pay. This is actually an explicit promise, unlike most of the others. It's actually in writing, and you know this if you've ever gone to a medical or a dental office or been hospitalized or had ambulatory surgery. You've been required to sign a financial responsibility form of some kind, where you actually promise and sign in writing to pay for services, even if your insurance doesn't cover whatever medical goods and services you end up buying. Obviously, not everybody ends up making good on the promise, but everybody is made to promise. Now, this is not a healthcare economics class, but in case you're curious, here's how the payment part works. About 55% of non-elderly Californians get their health insurance through their employer. The patient-employee promises to work, and the employer promises to provide some insurance benefits to the worker and their family. Now, a large employer could be self-insured, but most contract with an insurance company, promising to pay the insurance company money, and the insurer promises the employer that they'll provide the benefit. Note that the promise is actually between the employer and the insurer here. The insurance company pays the physician and the dentist and the optometrists and the podiatrists and the healthcare organizations, and in return they promise to charge the negotiated rate, not to bill for services they didn't provide or that weren't needed, and sometimes they're also required to promise that they won't provide certain treatments without the insurer's permission. For those entitled, which are most elderly and many disabled and low-income folks, prisoners, members of the military, veterans, and some others, the government, either federal or state, is the payer. The implications of this will be clear in weeks 11 and 12 when we talk about the regulation of healthcare organizations. Medicare, the federal program that pays for much of the healthcare of the elderly and some permanently disabled folks, has tremendous power, and it uses it to regulate the safety and quality of healthcare and to protect the rights of patients. We'll finish up this week with a quick look at the sources of law and the basic structure of government. This will be a review for many of you, and may not be necessary, but certainly for those of you that slept through high school civics, or for those of you that may not have grown up in this country, or for those of you that are just interested by these things for some reason, this should be all you need to know to be successful in this course, because it'll provide a framework for where these laws and regulations are coming from and the context. So governments in the U.S. have three branches. This is true for the federal government, established by the U.S. Constitution, and for all state governments, which are established by state constitutions. So the three branches hold each other in check and are supposed to have balanced power, although the balance of power has certainly shifted through decades. The three branches are the legislature, the executive, and the courts, also known as the judiciary. And as I said, this three-branch structure is mirrored at the state level as well. The executive branch technically includes administrative agencies of all kinds. We're going to talk about this in a moment, but administrative agencies are very important in the healthcare ecosystem. The branches of government may have slightly different names at the state and federal level. Of course, at the federal level, the legislature is called the Congress. It has two houses, the Senate and the House of Representatives. At the state level in California, we also have two houses, the Senate and the Assembly. The chief executive of the United States is called the President. The chief executive of the state of California and any other state or territory is the governor. Now I want to give you an example of how the checks and balances work, and we're going to use EMTALA as an example. I'm not teaching you about EMTALA right now. This is just an illustration. EMTALA is the Emergency Medical Treatment and Active Labor Act of 1984. It's a federal law, and it's had a very interesting history. It started in an era when, because of course in America there is no right to health care, there are certainly entitlements that one may be eligible for, but it's not viewed as a right, and so since it's a market good instead, there was this perceived problem of patient dumping. So folks having emergencies or in labor would show up at the hospital emergency departments of private for-profit hospitals or even not-for-profit hospitals, and because they didn't have insurance, they would be turned away and told to go to the county hospital. And there were some tragic deaths as a result of this practice, and no accountability for hospitals that were turning away people experiencing emergencies or who were in labor. So Congress responded and passed EMTALA. Congress wrote the law and specified that any person who comes to a hospital emergency department must receive a screening examination and stabilizing treatment if it appears that they're experiencing an emergency. So that's the law of the land, but it has to be put into a level of detail that hospitals can actually operationalize. And so for that, the law is then handed off to the appropriate administrative agency, which sits within the executive branch. In this case, it was the Centers for Medicare and Medicaid Services, which were back then known as HCFA. And so they wrote a first draft of regulations and rules specifying how to operationalize EMTALA requirements, put it out for public comment, finalized the rules, published them, and waited to see how they worked. And so the rule was written, and a few years later, there was a very tragic case. A 15-year-old boy was shot, mortally wounded. His friends brought him to the grounds of the local hospital, but I guess because they were afraid of being implicated in whatever was going on that led to the shooting, they dumped him out of the car and left him in an alley next to the hospital. The emergency department staff knew that he was there, but nobody was willing to go out and rescue him, so he bled to death right there in the parking lot of the hospital. The family brought a lawsuit, and the court agreed that the hospital violated EMTALA in refusing to treat this boy. His name was Christopher Searcy, in the parking lot. And so the courts sent it back. CMS became responsible for revising the regulation to update it in accordance with the court's opinion. And this is where the 250-yard rule came from. So they rewrote the rule, clarifying exactly what it means to come to a hospital emergency department. And they said it triggers EMTALA when somebody presents within 150 yards of one of the main hospital buildings on the hospital campus. And there's some additional rules and regulations defining terms and additional specifications, but that's an example of how the process works. So usually it starts with a law in Congress. It goes to the administrative agency, which is situated within the executive branch, for detailed rules to be written, which are then implemented. And if there are challenges to the rules, those will go through the court system, and the process then goes back to the administrative agency that has to revise the rules, or can go back to the legislature that created the law to revise the law to be in accordance with the constitutional requirements identified by the court. I should add, although I don't have a slide for it, that there are 3 levels of courts. Well, actually, since I'm creating the presentation, I'll just create a slide. Hang on. Yeah, there we go. So 2 systems of courts in the United States, and they're kind of parallel universes: the state court systems and the federal court system. So the vast majority of action happens at the trial court level, which in the federal system is called district courts. And then there are courts of appeals. The state of California is within the 9th Judicial Circuit of the federal court system. So in the news, if you hear something about the 9th Circuit, that is the federal court of appeals that has jurisdiction over California and most of the West Coast. And then there is a Supreme Court, which hears very few cases every year, but they tend to be important cases that require interpretation and application of either the state constitution if it's state court, or the U.S. Constitution if it's federal court. So I'd mentioned administrative agencies. What are those? So administrative agencies are created by the legislature, and they're supposed to be specialty bodies full of specialists in a particular topic. And so the ones that you will interact with and hear most about during your nursing careers are the California Department of Health, or whichever state you end up practicing in, it'll be the entity that licenses healthcare facilities. And then the California Board of Nursing, or the Board of Nursing of whichever state you end up practicing in. And at the federal level, the Centers for Medicare and Medicaid Services, always called CMS. Typically, the administrative agencies that you'll hear most about, and most, I would say 95% of the rules and regulations that govern your nursing practice and that bind your employer are going to come from these three agencies or their equivalent in other states. All right, and then sources of law. We should say a few words about the different kinds of laws and regulations that you'll be learning about and their different origins. So there's the civil justice system or civil laws. There are the criminal justice system and criminal laws, and then there are administrative rules and regulations. So let's sort those out. Civil law is the law of civil or private rights, as opposed to criminal law or administrative law. It actually has a very interesting history. You might have heard of trial by combat in ancient times. So historically, disputes between people or between families were resolved with violence. I'm talking about in ancient history for most communities. And then over time, that evolved into a blood price, so you could buy your way out of trouble. And in many countries in the Middle East, apparently that's still the practice. I have a colleague that worked in Qatar a few years ago, and he was explaining that you had to buy your way out of medical malpractice if you accidentally hurt or killed somebody, and the equivalent of the court would assign a price to your transgression, and you would have to pay the amount of a certain number of camels. So this is in Qatar, even in the modern era. Anyway, the civil law system evolved as an alternative to private violence and to having village elders assign a price in terms of she-camels. And the civil law system that we have today covers everything from torts like malpractice and negligence, and intentional torts like assault and battery and invasion of privacy. Talks about breach of contract and all the other things that are neither criminal nor administrative matters. Civil laws may be made by legislatures, in which case they're called statutes, or they can be made by court decisions, in which case they're called case law. And almost always they result in having to pay money damages to the injured person, and this could be a natural person, a human like you and I, or it can be a corporate person, right? Like two corporations sue each other over intellectual property violations or breach of contract, which is not uncommon. Contrast this with criminal law. These are offenses against society, offenses against the government, and criminal laws are only made by statute. They're only made by legislatures. There is no common law criminal code. Criminal events may result in imprisonment, and which is probably the most common. The difference between misdemeanors and felonies: misdemeanors mean you can be jailed for up to a year, and felonies result in imprisonment for a year or longer. Our third and also very important category is administrative rules and regulations. These are made by administrative agencies which got their mandate and their authority from the laws that created them, the laws being statutes created by the legislature. Administrative rules and regulations have the force of law. Administrative rules and regulations have the force of law, and violations of rules and regulations are enforced by administrative agencies, and that enforcement power can include monetary fines. It can also include things like injunctions, and sometimes the same statute that created an administrative agency and gave it the power to create rules and regulations, sometimes that same statute also creates criminal penalties for the violation of the rules and regulations that are created by the administrative agency. So again, the state boards of nursing are examples of administrative agencies. Well, that concludes our lecture for this week. Just as a reminder, make sure you do your syllabus quiz and your weekly review questions for the week. Those are due no later than midnight on Sunday. And if you have any questions about what we have talked about, or what I've talked about here, please email me. I really am just an email away. I want you to be successful in learning this content, and of course this was just a basic introduction and a framework for thinking about these issues. But as we go through the semester, even if we're not seeing each other face to face, please email me with your questions, and I'll do my best to get you a thoughtful and prompt answer. That's it. Have a great week.